It finally went too far. Judge Caldwell's legendary patience didn't just crack today, it snapped in front of cameras, in a packed federal courtroom, with a decision so explosive that veteran attorneys are still trying to process what they saw. This time, it wasn't just a defiant defendant feeling the full weight of the court, it was the defense. What you're about to hear is not standard courtroom discipline. This was a sitting federal judge looking at the very lawyers sworn to uphold the law and saying, in open court, you have crossed the line. This was not a fine, not a stern lecture. This was Marshals stepping forward as a judge uttered the words no attorney ever expects to hear directed at them. Counsel, you are now in contempt. Marshals, take him into custody. No warning recess. No quiet chambers conference. No second chances. In 90 seconds, the balance of power in that courtroom was rewritten. Because what triggered Judge Caldwell today wasn't a raised voice or a disrespectful aside. It was something far more dangerous. A deliberate leak of protected evidence, a secret recording known as the Witness 14 tape pushed into the public arena in direct violation of a court order. And according to the judge, the trail led not to some anonymous troll online, but straight back to the defense team itself. When a federal judge concludes that lawyers, the people who are supposed to be guardians of the process, have helped weaponize confidential evidence to poison the jury pool, that judge has two options. Pretend this is just another discovery dispute, or use every ounce of authority the law allows. Today, Judge Caldwell chose the second option. Here is exactly what happened inside that courtroom and why legal analysts across the country are calling this a turning point in how federal courts deal with defense teams that treat gag orders as suggestions instead of commands. The hearing was supposed to be simple. On the docket, it was listed as a status conference on pretrial motions and discussion of recent media coverage. That bland phrase hit a crisis. 48 hours earlier, a major cable network had aired audio it described as an exclusive leak of a key government witness, Witness 14, discussing threats, pressure, and behind-the-scenes coordination in this very case. The leak detonated online. Hashtags, reaction videos, commentators dissecting every word, supporters of the defendant claiming the tape proved a setup. Critics arguing it confirmed everything prosecutors had alleged. But one fact cut through the noise: that recording was under a protective order. No one outside a tight circle, prosecutors, defense counsel, the court, was supposed to have it. At 9:02 a.m., Judge Caldwell took the bench. Observers in the gallery noticed it immediately. This was not the measured, unflappable Caldwell they'd come to know. He was composed, yes, but there was no small talk, no easing into the day's business. He adjusted his glasses, glanced once at the packed gallery, and then looked straight at the defense table. "Be seated," he said. "We are here to address a matter of the utmost seriousness." According to multiple reporters in the room, you could feel the temperature drop. The government went first. The lead prosecutor rose, referenced the broadcast of the Witness 14 recording, and stated bluntly, "Your Honor, that tape did not leak itself. Someone with access to discovery violated your order. We believe the evidence will show that the source of that leak is sitting at the defense table." Murmurs rippled through the gallery. One of the defendant's attorneys shook his head, scoffing audibly. Another scribbled something on a legal pad and slid it to his colleague. The defendant himself leaned back in his chair, expression unreadable. Judge Caldwell held up a hand. "You will have an opportunity to respond," he said to the defense. "But first, the record." He turned to his clerk. "Mark as Court Exhibit A, the investigative report from the United States Marshals Service." That was the first sign this was not a normal evidentiary squabble. Marshals don't usually investigate leaks. They protect the court. They secure the building. When they are tracing email headers, pulling phone records, and analyzing access logs, it means a judge has already decided this isn't just bad behavior. It's a threat to the integrity of the proceedings. The judge summarized the report in a voice that remained calm, but everyone in that room could hear the steel underneath. "The court's protective order," he began, "was clear. The Witness 14 recording could not be disseminated beyond counsel, their immediate teams, and the necessary support staff. Within 12 hours of that order, defense counsel requested and received a digital copy. Within 36 hours, that copy, or a duplicate, appeared in the possession of a media outlet." He paused, letting the timeline hang in the air. The Marshals report traces the distribution path, he continued. Login records, IP addresses, encrypted communications. And it identifies a specific device associated with a member of the defense team as the last non-government access point before the leak. For the first time, the room saw visible movement at the defense table. One of the senior attorneys shifted forward in his chair, face flushed, whispering fiercely to the colleague beside him. Another defense lawyer stared straight ahead, jaw tight. Judge Caldwell looked directly at them. "Counsel," he said, "you may respond." The lead defense attorney stood. His tone was controlled but bristling. "Your Honor, with respect, this is an outrageous insinuation. We categorically deny any involvement in any so-called leak. The media has sources everywhere. We cannot be held responsible for what anonymous actors choose to publish. It was the exact argument observers expected. Blame the press. Blame sources. Suggest an invisible hand, anything but the people in the room. This is the moment that changed everything. Because instead of engaging in a back and forth, instead of asking for explanations, Judge Caldwell lifted a second document from the bench. "Counsel," he said, "your denials are noted. They are also contradicted by your own communications." He read, slowly, from what he identified as a court-authorized extract of a text message thread between a defense team investigator and an intermediary tied to the media outlet that aired the tape. The language was not subtle. "Clip is ready. Audio will blow this up. Need it out before jury pool locks in." According to the report, that message was sent from a phone registered to a contractor working under the direct supervision of lead defense counsel. Follow-up messages referenced witness 14 by number, and one explicitly mentioned protective order be damned. Gasps. Actual gasps from experienced reporters who thought they'd seen everything. The defense attorney tried to speak, but Judge Caldwell raised his hand again. "Sit down," he said. "You will not interrupt me while I address contempt." His voice was not raised. It didn't need to be. "Let the record reflect," he continued, "that this court issued a clear, unambiguous protective order. Let the record reflect that I warned all parties, on the record, that violations would be met with immediate consequences. Let the record further reflect that, based on the Marshals' investigation, a member of the defense team under your supervision engaged in an intentional act to disseminate protected evidence." He turned his gaze to one specific man at the defense table, the investigator whose name had appeared in the report. "Mr. Hale," he said, "stand." The man slowly rose, eyes flicking between the judge and the security officers at the back of the room. "Based on the evidence before me," Judge Caldwell said, "this court finds you in direct criminal contempt for willful violation of a protective order and for conduct designed to undermine the administration of justice." Then came the words that sent a shockwave through every defense office. "Watching. Marshals, take him into custody. Immediately. To U.S." Marshals moved from the side of the courtroom, hands already open, ready. The investigator turned as if to protest, but the judge spoke over him. "You will have counsel. You will have a hearing. But you will not leave this building today as a free man after what you have done to this court's authority." Legal analysts watching the live sketch feed would later say they'd never seen anything like it in a modern federal courtroom. A member of a defense team taken into custody on the spot for a leak, and Judge Caldwell wasn't finished. As the Marshals closed in on the investigator, everyone in that room understood something at once. Judge Caldwell hadn't just drawn a line with the defendant. He had drawn it around the entire defense operation. The investigator's chair scraped against the floor as he was led away. His legal pad, covered in hurried notes, lay abandoned on the table. The defendant watched, frozen. Lead counsel stared straight ahead, jaw clenched, hands pressed flat against the table to stop them from shaking. For a few long seconds, no one spoke. Then Judge Caldwell did something that experienced court reporters said they had never seen in his courtroom before. He looked directly at the lead defense attorney. "Counsel," he said, "you are on the edge of contempt yourself." The words landed like a physical blow. "I am going to give you precisely one opportunity," he continued. "You will sit down with separate counsel. You will review this record. And you will decide whether you intend to continue in this case under the rules of this court, or whether you prefer to test those rules from the other side of the bar." According to those present, the attorney's face drained of color. This is the part almost nobody outside the legal world understands. When a judge moves against an attorney or member of the defense team, not just a defendant, it doesn't just sting, it detonates the entire strategy, every motion, every media statement, every whispered plan to fight this in the court of public opinion. Because you can't fight in the court of public opinion if the real court decides you can't be trusted with the evidence anymore. And that is exactly where Judge Caldwell steered the hearing next. Without raising his voice, he announced that effective immediately, he was suspending the defense team's unsupervised access to sensitive discovery. All materials falling under the protective order, he said, will now be reviewed under controlled conditions. No copies leave secure facilities without prior authorization from this court. In one sentence, he cut off the oxygen to a strategy that had depended on selective leaks and online outrage to shape the narrative. Legal analysts watching from afar knew exactly what they were seeing. This is a judge who has reached his limit with trial by media tactics. Former federal prosecutor Elena Morales told a legal outlet within hours. He didn't just punish the leak, he amputated the pathway that made the leak possible. That's surgical. But to understand why Caldwell moved this decisively, you have to rewind the clock. Because this confrontation didn't start with the Witness 14 tape. It started the first time the defense treated his courtroom like a backdrop instead of the main event. Months earlier, at a hearing so routine most networks didn't even cover it, the defense had floated the same idea that would later explode into the leak. If the jury pool could be primed, if public opinion could be inflamed, maybe the government would back down. Maybe the judge would start to flinch. It began with small things. A sideways remark to reporters on the courthouse steps, suggesting that the people deserve to see all the evidence, not just the cherry-picked version the government likes. A late-night cable segment where one of the attorneys hinted that if the public heard what certain witnesses have actually said, they'd be shocked at how weak this case really is. None of those comments technically violated the gag order. They danced at the edge. But judges notice patterns, especially judges like Caldwell, who have spent decades watching defendants and lawyers test limits the way toddlers test boundaries, 1 inch at a time. So he issued what, at the time, looked like a standard warning. This court will not tolerate attempts to litigate this matter through leaks, he said at that earlier hearing, according to the transcript. You are officers of the court. You will conduct yourselves accordingly. Consider yourselves on notice. The defense heard the words. They did not believe the threat. In the weeks that followed, social media accounts loosely connected to the defense began dropping hints. Vague references to witnesses with shaky stories. Cryptic posts about tapes the government hopes you never hear. Cable commentators, fed just enough to be tantalized, speculated openly about bombshell recordings and justice being suppressed. Prosecutors watched. Pre-trial services watched. So did the Marshals. It was only a matter of time before someone tried to turn implication into impact. That moment came when the defense team's own investigator, now in custody, allegedly suggested a shortcut: get the Witness 14 tape out, not through a formal motion, not through a public filing the judge could control, through a media leak. It was, in many ways, the perfect symbol of the strategy that had brought this case to the brink. Skip the rules, weaponize the spectacle, dare the court to respond. What the investigator and, crucially, the people supervising him appear to have misjudged is that Judge Caldwell had seen this movie before. He had watched other high-profile cases devolve into circus atmospheres where court orders were treated as suggestions and protective orders as puzzles to be solved, not obligations to be respected. There is a concept every seasoned federal judge understands. You do not pull the trigger on your full authority the first time someone steps out of line. You build a record. You issue clear orders. You document warnings. And then, when the moment comes, you act with justification already in place. That is exactly what Caldwell did. His written protective order had spelled out consequences for violations. His earlier statements on the record had underlined the seriousness of leaks. His instructions to the Marshals to investigate showed he expected to have to back up his words with action. So when the Witness 14 tape emerged in public, he was not improvising, he was executing. And the impact went far beyond one investigator in handcuffs. Defense attorneys across the country are already rewriting the advice they give clients and staff tonight. Those who have grown comfortable treating protective orders as flexible guidelines are sending a different message after watching this unfold. If you try to play games with sealed evidence in Caldwell's court, you might not just lose emotion, you might lose your freedom. Former appellate judge Patricia Hammond, now retired, put it bluntly in an interview. This is going to be taught in judicial conferences. He didn't just sanction, he contained. He showed how a court can claw back control when lawyers treat the process as content for social media. But the most brutal implications land squarely back on the defendant. Because here's the part almost nobody in that gallery had fully processed in the moment. When your own team is accused of turning protected evidence into ammunition for the outrage machine, your entire "I'm just a victim of bias" narrative starts to collapse. You can't spend months attacking the judge as unfair and the system as rigged, then get caught violating the very orders that are there to ensure a fair trial, and expect anyone outside your most hardened supporters to buy the story anymore. Inside the defense camp, that realization hit immediately. According to sources familiar with the case, within an hour of the hearing ending, emergency meetings were underway. Separate ethics counsel were being retained. Senior figures inside the team were asking an unthinkable question. Do we stay on this case, or does this blow us up completely? Because if the judge concludes that lead counsel either directed or tolerated the leak, disqualification is on the table. And if the bar authorities decide ethical lines were crossed, careers, not just one case, are suddenly at risk. Meanwhile, prosecutors, who had spent weeks being outshouted in the media, suddenly held the only thing that matters in a courtroom, the moral high ground backed by a clean record. This is why we insisted on the protective order, one member of the prosecution team told a colleague, according to a source with knowledge of the conversation. You can scream witch hunt all you want out there. In here, the transcript wins. If you're starting to see how this one decision is rewiring the power map in this case, stay with it. Because what happens next doesn't just affect this defendant or this defense team. It affects every high-profile case where lawyers are tempted to treat court orders as obstacles instead of obligations. And Judge Caldwell hasn't even dropped the most consequential hammer yet. Because for all the drama of an investigator led away in handcuffs, the most explosive question still hanging over this case is simple. Will Judge Caldwell stop at the team around the defendant, or will he go further? Within hours of the hearing, legal commentators began circling the same two possibilities. Either this was Caldwell's one, carefully chosen lightning strike meant to restore order, terrify would-be leakers, and then let the case proceed. Or it was the opening move in a broader campaign to claw back control from anyone who thinks a federal courtroom is just another stage in a political performance. The answer will depend on three decisions that are now in motion simultaneously. The first will come from the defense. They have a narrow window to decide whether to double down on defiance or pivot to damage control. Double down, and you continue railing against bias, calling the contempt finding outrageous, insisting the leak allegations are fabricated revenge by a hostile court. Damage control, and you distance yourself from the investigator, pledge full cooperation with the inquiry, and try to convince Caldwell that the problem has been surgically removed. Every defense lawyer watching knows which path is smarter. Rule number one when the judge is already furious, former public defender Natalie Reyes said on a live stream, is you do not pour gasoline on his shoes. You apologize, you fix what you can fix, and you stop treating the court as your opponent. Right now, this team is in a hole. They can keep digging, or they can put down the shovel. The second decision will come from outside the courtroom entirely, the bar authorities. Judges have power in the moment. Bar associations have power in the long term. If Caldwell refers the conduct he just documented to the state disciplinary board, this stops being just a contempt flare-up and becomes a professional survival question. Suspension, disbarment, conditions on practice. Those possibilities will be hanging over every conversation inside that defense conference room tonight. And the third decision, the one that matters most, will come from Caldwell himself. He has tools he hasn't used yet. He can reopen the issue of bail, arguing that involvement in, or even proximity to, a deliberate campaign to taint the jury pool shows the defendant cannot be trusted on any condition of release. He can tighten gag orders further, not just on the lawyers, but on the defendant personally, and tie any violation to immediate detention. He can sever counsel and order the defendant to find a new team under strict conditions, effectively wiping the current strategy off the board. None of that is theoretical. It is all within the power of a federal judge, who can now point to an 11-page record of a violated protective order and a contempt finding already in motion. So where does this go from here? Based on the patterns we've seen in cases like this, and based on Caldwell's own history of patience followed by decisive enforcement, there are three realistic scenarios. Scenario 1, the controlled burn. In this outcome, the investigator remains in custody pending a contempt hearing. The defense team throws him under the bus, arguing he went rogue. Caldwell accepts a narrowly tailored cleanup. There is no immediate disqualification of lead counsel, but strict new conditions wrap around the team. Discovery access stays locked down. Any further leak or edge skating ends their involvement for good. Probability? High. Judges generally prefer to contain the damage rather than blow up entire defense tables unless they absolutely have to. Caldwell has made his point. He may decide he doesn't need to detonate more charges to keep control. Scenario 2, the wider purge. Here, the trail of communications, if fully revealed, shows that the leak plan wasn't just the brainchild of one reckless investigator. It was known, discussed, maybe even approved at higher levels. If that's what the record ultimately shows, disqualification becomes more than symbolic. Caldwell could remove lead counsel entirely, appoint standby or CJA counsel to ensure the defendant isn't stranded, and refer everyone involved to disciplinary authorities. That would delay the trial. It would inject new appeals issues, but it would also send the clearest message possible. If you treat this court's orders as suggestions, you do not practice here anymore. Probability? Lower, but rising for every text, email, or message that surfaces, tying more people to the leak. Scenario 3, escalation beyond the courtroom. If prosecutors decide the leak and the subsequent online firestorm crossed into witness intimidation or obstruction, this doesn't stop at contempt. It becomes a new criminal exposure, obstruction of justice charges, tampering, additional counts layered on top of an already serious indictment. At that point, the media strategy that seemed so clever in late-night green rooms would go down in law school textbooks as a case study in self-inflicted disaster. Probability? Unclear, but do not underestimate how seriously federal prosecutors take attempts to weaponize protected evidence against vulnerable witnesses. And remember, Caldwell has already signaled, in the cold language of his orders, exactly how he sees all of this. He has described the leak as an effort to undermine the administration of justice. He has labeled the conduct willful, calculated, and in direct defiance of this court's authority. Those are not throwaway phrases. Those are the building blocks of higher charges and harsher sanctions if this doesn't stop here. But step back for a moment from the details of this one case and look at the bigger picture. What today really tested was a question that has been hanging over every high-profile prosecution in this era of viral clips and weaponized outrage. Can a federal courtroom still function as a place of law when the people inside it are constantly tempted to turn it into content? Every time a defendant walks into a hearing thinking more about the cameras than the judge, that question gets sharper. Every time a lawyer treats a gag order as a puzzle to be gamed instead of an instruction to be followed, that question gets harder to ignore. Every time a piece of sealed evidence miraculously appears online with commentary attached, that question moves from theory into crisis. Today, Judge Caldwell answered in the only language that matters in his world: custody, restrictions, orders with teeth. He did not call a press conference. He did not go on cable to defend himself. He did not tweet. He used Marshals and ink and the power of his signature to remind everyone that the courtroom is not neutral territory in a media war. It is his domain. And within that domain, there are lines you cross at your peril. For defendants and lawyers far from this case, the lesson is brutal but clear. If you want to fight in the public arena, do it without dragging protected evidence and gagged witnesses into the arena with you. If you think rage clicks and trending hashtags are more important than the judge you face at 9 a.m., remember that the algorithm cannot overrule a detention order. Social media cannot walk into a cell and unlock the door you talked yourself into. For citizens watching from the outside, exhausted by years of headlines that make it seem like rules only apply to the powerless, today offered something else. a glimpse of a system that, when pushed to its limit, can still push back. Not perfectly, not evenly, not always in time, but decisively, when the record is built and the moment arrives. In the days ahead, you will see statements from the defense, outrage from supporters, debates on cable about whether Caldwell went too far or not far enough. Appeals will be filed, motions will fly. Commentators will argue over precedent and proportionality. Underneath all of that noise, the reality is simple. A federal judge told officers in his courtroom to take someone into custody for turning the law into a prop. He tightened the walls around sensitive evidence. He made it clear that the price of playing games with his orders is measured not in clicks but in handcuffs. What happens next, the appeal, the trial, the disciplinary process, will determine whether this becomes a footnote or a template. Other judges are watching, so are other defendants. So are other lawyers wondering just how far they can push. The next few weeks will answer a larger question than anything on the docket. When courts are treated as stages and evidence as ammunition for culture wars, will the judges in those courts still be willing to say, enough, and mean it? In Judge Caldwell's courtroom, at least for one explosive morning, the answer was unmistakable. The performance stopped. The process reasserted itself. And for once, in a system so often accused of being too timid with the powerful, the message was not delivered in a press release or a speech, but in the quiet click of a door closing behind someone who thought the rules did not apply to him.